Hello, good morning. It is January 4th, 2025. It is Saturday at 10. I'm Meghan Mays, and this is Being Civil in Minnesota. I'm here every Saturday at 10 to talk about legal issues, the court process, questions you might have. This is not necessarily going to be legal advice, nor does this make me your lawyer. I like to come here, make sure people are getting the right kind of information and pointed in the right direction. I'm very sure that it is Saturday, the 4th of January, because I've checked probably 10 times. I don't know about you, but there's this haze between the end of December and January of the next year where it's just sort of a cheese-filled fog. So it is Saturday. I'm now very sure. So thanks for joining me this morning. Today we had some member questions. You can post your questions online at the Facebook group Being Civil in Minnesota. You can post them anonymously so you don't have to share any personal information that you're not comfortable with. We had a couple members from the group ask some questions, and so we are going to talk about those member questions, and those questions have to deal with taxes and deadbeats. The first question that I got was from Katarina Stone, and the question was, what is the contempt process like if post-divorce someone starts missing maintenance payments? How soon should you take action after threatening action? How soon can that be done? So, in the state of Minnesota, there is ways to enforce payment of a order. The process is called contempt, and you can find instructions and forms on the Minnesota Judicial Branch website. Contempt is a process where, one, there's a court order that says, yes, you have to do this. Two, you're aware of that court order and you did not do that. And three, there really wasn't a great reason why you didn't follow the court order, meaning if it's non-payment, a good reason why you're not able to pay may be that you broke your leg and you're not currently working. Not a good reason would be, well, because I'm working for cash under the table and I just don't want to pay them, right? There's a spectrum of reasons. And every judge is different. Every situation is different. One of the things that courts don't want to see is people using the contempt process as sort of just a knee-jerk reaction. Courts are kind of, at least in the civil family court process, there are ways that you can get into court quickly, but a lot of times courts are reactive. You don't want to go in after they've missed one payment, right? Because that's the rule requires that they have to be behind at least 3 times what their court-ordered obligation was. So if they're supposed to give you $2,000 a month, you can't go in when they're $4,600 behind. You can't also go to court if they're already on a payment plan and they're kind of trying to comply with the payment plan. If a court does find them in contempt, the court can order them to do 32 hours of community service for up to 6 weeks. I've not seen this happen. Typically courts will threaten lots of kinds of sanctions for non-payment of, at least in the child support realm. So the community service could be a very good motivator. It might be nice to see someone out there doing some good if they're not going to be paying their court-ordered obligation and they have a way to do so. The question was about spousal support or maintenance, but I found a really interesting rule while I was looking this up this morning. Rule 518A.74. That rule allows the publication of up to 25 delinquent parents that owe more than $10,000 in child support. So if there's a parent or a responsible party out there that owes more than 10 grand in child support, their picture, their information, the amount of arrears they're in, up to 25 people can have that information published. And I don't know exactly how you guys submit nominations for these kinds of awards or what the process is, but may the odds be ever in your favor if this has any interest to you. The other question I got was from a member, and they wanted to know about taxes. If there's not a custody agreement, if you're not married, if you have all the responsibility and none of the assistance from the other parent, and there's not a court order, the IRS says that a qualifying child is a child that lives with a parent for more than 6 months out of the year. So if that kiddo's been with you, you've been doing all the stuff, there's not a court order that says otherwise, they're under 19 and not like super rich and supporting themselves somehow, which if you know how to do that with your kids, let me know. I would be very interested. And so that means that child would be your qualifying child. And custody labels are not necessarily relevant. The IRS looks at overnights. So if there's no court order, kid's been with a parent for more than 6 months, then according to the Internal Revenue Code, then that's a qualifying child of the parent that the child is living with. If a parent does wrongfully claim a child on their taxes, there is something you can do about it. And there's a process that allows you to go to court and tell the judge that somebody has wrongfully claimed your child on taxes. That other person who does that will have to pay you what you would have gotten had you actually been able to claim your taxes, plus any costs and any reasonable attorney's fees. So the person who posted this claim says that their ex is threatening to claim them on taxes. Well, I'm sorry that is happening. Unless there's a court order that says that they have a right to claim the child on taxes, that's not a great threat, because they're opening themselves up to liability for both compensation and the costs and attorney time. So now, if you do bring a claim that says somebody wrongfully claimed my kiddo on their taxes, and it turns out that that's not the case, that you're just doing it to be a pain, the court can then order you to pay the costs and the attorney's fees, because that's not really what the process is for. So, contempt for non-payment of spousal support, 3 times the minimum, no payment plan, forms are online. Tax returns, if the child is your qualifying child, meaning living with you for more than 6 months, or and there's no other court order, then that would be your qualifying child. Be sure to look at your support orders, because sometimes even if there is a provision that says that the other parent can claim a child on their taxes, there's usually a provision that says they must be up to date on their child support payments. So there's the right to claim the child, but they also have to do the obligation of paying for that child. So we're doing it. It's 2025. If you have any other questions about these topics, go ahead and post them in the comments. If you have questions about other things, please post them in the group Being Civil in Minnesota. And I will see you guys next Saturday. Take care.